Peter, thanks. Again, very clear and within the time, largely within the time. Now, let me give the floor to the third speaker, who is David Pitlarge, who is partner of Hill Dickinson, and he will speak about a continuing headache, failure to pay under period charters, some practical and legal issues. We all know that there are cases, and David will touch them that are of great interest in these days. Thank you. Please, David.
Thank you very much.
No.
Thank you very much, Mr. Chairman. Good evening, ladies and gentlemen. Both Bruno and Peter have set quite a stiff task in trying to beat them on the time. I think my slides are slightly longer, but I'll race through them. I must confess that the title is one you've heard before and is not the most arresting title. Francesco, as usual, urges us to be topical, so I'm going to look at a couple of news stories that I picked up on and then look at some of the new cases, rather like a checklist fashion, so we can consider where the law is going on these. And they are, and hopefully this will give rise to some practical suggestions in anticipation of the problems which we're likely to face, which I think both Bruno and Ugo touched on. I was very interested to hear Ugo's comments about oversupply, because a striking feature which I think had some shockwaves into the market and affected some of the cases I was dealing with was the decision by Costco in August to stop paying charter hires. We'll look at how they describe that in a minute. But there you can see the headlines. Actually, and this made, it was quite a high-profile story in the Financial Times. If we roll on 3 weeks, our good friend Jim Davis turned up to collect his Lifetime Shipping Award at the Lloyd's List Global Awards. And those of you who know Jim know that he's a very life-affirming and positive character, but his message was a rather bleak one. And we can look at a little bit more detail at what he was saying. And he's talking about bankruptcies and blood on the carpet. He's not mincing his words. If we go to Costco's position again, we can see that their position was described in slightly more euphemistic terms, and some of the reports, again from the Financial Times, I've put up there so that you can read them. Reneging on contracts, arrests we see following, adjustment of hire rates as part of normal operations and consistent with business philosophy. Sounds a little bit troublesome. Withholding payments under a cost reduction program to maximize value for shareholders. Now, we'll get to the law in a minute, but I don't think you need a lawyer to tell you that it's not a proper discharge of your functions to withhold payments. That's not serving your shareholders well. So, what is the continuing headache? I think, and again, Ugo's touched on this, we are where we were in 2008. It is still very difficult to secure your revenue streams, and I think the prudent operators will do everything they can and perhaps do a little bit more than usual to make sure they're well placed when trouble hits. The first thing I want to just look at is the most recent case there is the dynamic, but it's quite, I think it's worthwhile just reflecting on what happens when someone stops paying you hire, which is sometimes called early redelivery. Now, the basic principle starts rather inauspiciously with a case concerning adverts on dustbins. Now, in that case, there's authority for the proposition that when someone stops paying, you have a right of election. You can either terminate the contract, and here we're talking about something more than simple failure to pay. It's a repudiatory breach, and we'll look at that point in a minute. But someone stops paying, they say they're not going to perform, you can either terminate the contract and claim damages or proceed and claim the contract price. The problem was there was a passage in that judgment which suggested that if there was no legitimate interest to holding someone to the contract and claiming the value, then you couldn't do so, you had to take your damages. And that was picked up subsequently in the leading case of the Puerto Buitrago, which affirmed that if damages are adequate, and if it's wholly unreasonable to demand performance, then you should take your damages and not hold the party to the charter claiming your hire. A semantic point there that no legitimate interest became wholly unreasonable. personally, I have a bit of a problem with both of these. It doesn't seem to me wholly unreasonable to ask someone to pay the hire they've agreed to pay, and I think I do have a legitimate interest to secure a regular flow of revenue, particularly as in many cases that's assigned to the bank. Anyway, that is the law at the moment. I don't think it's displaced by the decision in the dynamic. The one thing we saw in the dynamic was that it clarified that it's the burden on the charterer, if you are holding them to the contract, to say that it's wholly unreasonable. Now, here we're talking about repudiation and damages. It might well be in damages we know from, indeed, our friend Clive Aston's speech last year, that damages is generally the difference between the charter rate and the market rate, always assuming there's an available market. And there are some new cases on that, but I won't go to them today. It might well be that you want to cash in. There might be some big money and a good debtor with reasonable prospects of enforcement. The question then arises, and I think it came up in Bruno's excellent speech, that would a simple non-payment enable you to terminate the contract and claim your damages, looking on the basis we've just suggested? And I think there was a passage in a judgment of Mr. Justice Andrew Smith in the Cos which suggests that a simple failure to pay without more, and here we're talking about someone not advancing the hire rather than telling you I'm not going to perform the contract, or some of this hogwash about rate adjustment programs. Simple non-payment will not allow you to treat the contract as repudiated, and indeed it might well be that if you then exercise your right to withdraw, you would shut out your right to damages. So again, from an executive point of view, if you're faced with this situation, you've got to sit down and think whether you want to preserve your right to damages, whether the charterer has done enough, and whether simply withdrawing is going to preclude a substantial claim. You will, of course, get your unpaid hire. Now, I don't know how I'm doing for time. The anticipation of problems is something, again, I think the list or the advice we're giving, some of the practical issues, are those that have been there for the last 3 years. A classic way of avoiding the problem with a troublesome or illiquid charter is to have secure guarantees. The business moves on with the medium, and we have, there have been some recent cases on emails and the formality of guarantee. For those not familiar with the English law principles, this is one area where it does require a written memorandum. The Meta case was interesting there because there was no printed signature. Under the statute of frauds, it's important that the guarantor actually signs the contract. And the argument in Meta and Fernandez was that in the absence of a printed signature, the subsequent email address and print at the top of the email was a sufficient identification of the guarantor, and that failed. The issue is still topical in the substantial Golden Ocean case, which I've cited there, and in that case, the argument, as I understand it, was that in the early part of a series of fixture exchanges, Salgokar had guaranteed the performance of a charter called Trustworth. Now, in the last email, the guarantee didn't appear, and it was suggested that the statute of frauds formalities were not complied with. Now, that's so far been dealt with on a summary judgment application, but leave has been given that there is a good arguable case that even though the guarantee was effectively left behind in the negotiations, it is compliant with the formalities. Other things you should look at. You want to make sure that the wording is sufficient to give you an immediate right of enforcement against the guarantors. Another danger is where there is a principle under English law where if the principal contract is varied, the guarantee might be discharged. So in such cases, you have to ask, let's say you reschedule a charter or enter into an addendum, you want to make sure that your guarantee will stand that. The lien is a surprisingly enduring right, And again, the watch list there would be to make sure that you always provide for sub-hires. As many of you know, the authorities are divided on that. If your charterer is in a jurisdiction where you have to register charges, as in the case in England, for example, you might also consider registering your rights to lien the receivables of that charterer, because certainly under the English law, where that would be deemed to be a registrable right under the Companies Act, if you fail to do that within 21 days, then you will lose the right. Penalties. If you try to anticipate the claims that you might have, you might think about, as they did in the Paragon, legislating for something a little more. The rule against penalties is simple. If what you provide for is a deterrent, then you won't be able to enforce it. If it's a genuine pre-estimate and not a deterrent, then you can claim. And I've given you two cases there which go either side of the line. The word buyer should in fact read builder for the Benetti case. Default provisions, I'll come to in a moment. Dispute resolution clauses. I think it's very important that you don't fetter your rights to seek immediate relief, whether that's injunctive relief or an early award from the tribunal. In B&S, a freezing injunction was discharged because there was a type of clause, a Scott and Avery clause, which obliged the parties to exhaust their arbitration rights before going to the court. Typically, you don't see those in shipping contracts, but you do in commodities and construction contracts. Avoid them. Mediation clauses can have the same effect. I'm not going to talk about the Sibbo-Hell, which was a case, it sounds obvious, but do make sure that the parties who contract are in fact the right parties. That was a case in which the subsidiary, the parent of the subsidiary disponent owner was referred to in the contract, and that contract was held not to be enforceable. It was enforceable by another means, but again, identifying the parties is important. I've dealt with... 2 minutes, okay. The last point, and I will leave bankruptcies because that's topical, is insolvency type clauses. I go back where we started with the Costco story, and as I think Simon Curtis identified today, this is a rough and ready business. It's not for widows and orphans. And one can imagine how people would have these discussions saying they don't have the money, or in Costco's case, they suspend the payments. Now that might seem quite a good negotiating strategy, but do think about the effect on your other contracts. For example, if you have derivatives positions with ISDA contracts, with typical insolvency wording, then doing any of the things in the first line there might well, at the very least, suspend your rights to draw down on those contracts. Similarly, it might put you in breach of your loan agreements, and if you've got charter party default clauses, then you might be in trouble there. So again, think before you speak is the motto there. I was going to touch on bankruptcy and insolvency procedures because I think that's topical, but Ugo is looking at me, and so I'm not really a specialist in that area. I will leave it there for tonight. Thank you very much indeed.